Doc Talk. Yeah, we keeping it smooth. Your favorite paralegal got the legal groove. From the stars in the courtroom to your cousin's case, we breaking it all down. No rush, just pace. Whew, there is a lot going on, and I have been going down the rabbit hole. I have read every affidavit filed in the Carmelo Anthony's motion for new trial, and here is what they prove. Carmelo Anthony's motion for a new trial doesn't just make legal arguments, it comes with 8 sworn statements from real people who tried to watch this trial and couldn't. Today, I'm reading through each one and showing you exactly how they plug into the same 4 factor test that already reversed 3 Texas convictions, 2 this year and 1 in 2012. I'm Cassandra, aka your favorite paralegal, and this is Legal Doc Talk. Now, a quick legal setup before we get into the individual statements. This video reads from sworn affidavits and declarations that were filed as exhibits in the motion for a new trial in the state versus Carmelo Sincere Anthony. These are defense's own filed exhibits. The state has not yet responded to or cross examined these accounts, and no court has yet ruled on the credibility or legal effect. This video is for legal education purpose only and does not constitute legal advice. All individuals here are presumed innocent unless and until proven guilty. All right, so before we get into that, as I stated, um, under Cameron versus State and Lilly versus State, whether a courtroom was closed isn't judged by what's written in the order. It's judged by the totality of the evidence. That means how the restrictions actually played out in practice matters just as much as the paperwork. So early this morning, pretty sure you guys viewed the video where I broke down Judge Roach's amended order regarding courtroom policies and all that other good stuff. Okay. Yes, that matters, but what really matters is what actually played out, because they don't have the court reporter transcript. They can't tell what was on record and what was not on record. They don't even have the court filing, the case filing for that matter. So, this is exactly why these affidavits are needed. They are sworn and notarized accounts from members of the public, and in one case, the defendant's own grandmother describing what actually happened when they tried to get into the courtroom. And they offered specifically to support the Sixth Amendment argument in the motion. So I hope everybody, I'm trying to do the series in order so you guys can have an understanding. If you have not seen my previous videos, definitely start with the motion for a new trial read and then work your way up. So that, because everything is in line. So everything that I'm doing from that point to now, it is in regards to the motion for a new trial. So what we're going to do is we're going to go through them in order, and I'll read the key facts from each, and I'll flag the exhibit number so you can follow along if you're looking at the filing yourself. Okay, again, if you don't have this, please reach out to me and I will email this to you. And if you email me, I have not checked my emails because I got emails for each business. So I'll be busy. But if you want a copy of this, please let me know and I will definitely get you a copy of that. Now, the first exhibit, Exhibit 12, okay? This is Key West. She does have an Instagram. Uh, I, I've seen her on Instagram. So if you have not subscribed to her, definitely go out and subscribe to her. But this is the affidavit of Kiera, and hope I'm saying your name correctly, Key West, member of the public, excluded from trial. Okay. Let's see. So I'm not going to read all of this, just pretty much saying that she is the member of the general public. She has no role in this case and no professional media affiliation. But let me start here, number four. So on June 1st, 2026, the day of jury selection, I went to the Collin County Courthouse and sought entry to the courtroom to observe the proceedings. I was denied entry. I was told by Head Security Officer Hammock or Hammond that the area was restricted only to jury members. There were no signs, posted restrictions, or written policy supporting this claim. When I asked for clarification or supervisory review, Officer Hammock or Hammond refused to identify or contact an administrative supervisor. I filed a complaint documenting misrepresentation of courthouse policy, enforcement of non existent rules, refusal to provide supervisory access, and improper use of authority by a courthouse security police officer. No overflow room, alternative viewing location, audio feed, or video feed was made available to the members of the public who could not be seated. Had an overflow room been provided, I would have used it to observe the proceedings. I returned to seek access on June 6, 2026, and gained entry, but was later physically removed by Officer Hunt, a police officer assigned to courthouse security. I was removed after making a nonviolent, factual, and protected statement inside the courtroom. Officer Hunt falsely accused me of inciting violence, but I did not raise my voice, threaten anyone, or engage in any disruptive behavior. My removal occurred publicly in view of multiple courthouse police officers and staff. I have filed a complaint documenting removal without lawful cause, false allegations made against me, failure to recognize protected speech, retaliatory enforcement inconsistent with courthouse policy, and public removal intended to intimidate or silence an observer. After my removal, my son also attempted to enter the courthouse on June 6, 2026. He was wearing a shirt with expressive content. He was asked to turn his shirt inside out by a courthouse security officer and complied. After passing through the security area, he attempted to use the restroom but was denied access by Head Security Officer Hammock or Hammond. There was no signage restricting restroom use, no posted policy, and no legitimate security concern. My son was denied by the same officer who denied me access on June 1st, 2026. I filed a complaint documenting this as retaliation toward a minor and misuse of authority. During the time I was present, I observed a pattern of targeted behavior by courthouse security police officers, including inconsistent enforcement of rules, retaliatory conduct, personal hostility, attempts to restrict access without cause, and targeting both my son and me. During the time I was present at and around the courthouse, I observed no disturbance, security incident, or disruptive conduct by members of the public that would explain or justify excluding the public from the proceedings. All right, so here is the affidavit for Miss Jacqueline Denise Yon. Hope I am saying her name correctly. Okay, so she is a member of the public who traveled from North Carolina. And this reads, I arrived in Dallas area on June 3rd, 2026. I hope to attend the trial beginning with the first day of testimony after jury selection. On June 4th, 2026, the first day of testimony, I went to the Collin County Courthouse to observe the proceedings. So this is June 4th account. I arrived at the courthouse approximately between 8 o'clock to 8:30 a.m. There was no line outside the courthouse, so I went inside and upstairs, where I found a long line of members of the public, approximately 80 to 100 people. I took my place at the back of the line, and others continued to line up behind me. I briefly left the line to use the restroom and returned at approximately 9 a.m. When I returned, I saw that the line was dispersing. Only approximately 27 members of the public were admitted into the courtroom, and I was not among them. So let's see. It says an overflown room had been used, but the rule changed that morning. So before June 4th, I was informed by friends who had attended that court staff had been admitting members to the public into an overflow room and had been letting in as many people as there were seats available. On June 4th, that practice changed. I understood that the rule had been changing that morning so that only approximately 27 people would be admitted and no overflow room was made available to many others who sought to attend. Then she said I was unable to attend and the restriction continued. So I remained at the courthouse but was unable to gain entry on June 4th, 2026. I spoke with a couple of sheriff deputies to ask why more members of the public were not being admitted. I was told that this was simply the rule for that day. As far as I was able to determine, the same restriction remained in place for the rest of the week. The deputies told me that if a person left after lunch recess and did not return, a person might be admitted in their place. But given how strict the rules were, I did not attempt to gain entry in that manner. Because of the conditions, I decided to spend the remainder of the week outside the courthouse with other members of the public who had gathered there and were unable to get in. I was informed by other members of the public that some of them had already had our I'm sorry, had our golly, had arrived at the courthouse as early as 3 or 4 a.m. and still had not been able to gain entry. During the times I was present at and around the courthouse, I did not observe any disturbance, security incident, or disruptive conduct by members of the public that would explain or justify excluding the public from the courtroom. Exhibit 14, this is Miss Tara Allen. Tira Allen, hope I'm saying, and I do apologize if I butcher anyone's name. It's charted to my head and not my heart. I think that's the same. All right, so Miss Allen, she flew in from Arizona to attend this trial. All right, so let's talk about we're looking at now. Remind you guys that we're looking at Cameron. That Cameron versus State dealt with specifically jury selection. So keep up. On Monday, June 1st, 2026, I attended and was able to watch the jury selection proceedings from an additional viewing room, which I understood to be referred to as the Oval Room. On Wednesday, June 3rd, 2026, I again attended what and was able to observe the jury selection for dear proceedings. Let's see, on Thursday, June 4th, 2026, the first day of testimony, I arrived at the courthouse at approximately 6:30 a.m. I was told that based on the judge's instructions, the deputies were not permitting anyone into the courthouse parking lot until 6 a.m. When I arrived at 6:30 a.m., members of the public were already lined up inside the building. When I asked others what time they arrived, some people near the front of the line said they had lined up outside the courthouse by approximately 5:45 a.m. Before 6 a.m. Before the 6 a.m. time, the judge's instructions had set for access to the property. I pointed this out to two deputies whose name I understood to be Hunt and I believe Holcomb. I stayed in line that day but was not able to get inside the courtroom. When I asked about an overflow room, I was told the courtroom where the trial was taking place was the only room that did not have video conferencing Zoom capability or the ability to record, and that this was given as the reason no overflow feed was provided. Jury selection had taken place in a different courtroom. other attendees and I whether we could be seated in the room we had used on Monday and Wednesday in order to listen to the proceedings, but we were told no, and that the judge had said there was no overflow room. On Friday, June 5th, 2026, I arrived at the courthouse at approximately 6:04 a.m. There was no direction given to arriving members of the public. I asked the deputies how they were controlling the line because people were walking up and joining others they knew who were already in line. And some people were displaying a badge and claiming to be media, even though credentialed media should not have been standing in a public line. The deputies told me that they did not have instructions on how to control the line, that it was up to the attendees how they lined up, and that they were only to keep things calm. Each day, a group of people claimed to be media did not appear to be credentialed media. They may have operated social media platforms, but did not have a media pass. The 9 individuals who held designated media passes would arrive later, obtain their passes, and go directly into the courthouse without waiting in the public line. On both June the 4th and Friday, June 5th, 2026, I was not able to gain entry to the courtroom. On each day, I waited until after the lunch recess, but I remained too far down the line to have any realistic opportunity to be admitted. On Saturday, June 6th, 2026, I was at the courthouse at approximately 4 a.m., waiting and driving around the property. The parking lot was barricaded so that cars could not enter as they had before. At approximately 5:30 to 5:40 a.m., I noticed a line beginning to form outside the entrance to the courthouse, so I was dropped off at the corner in order to join the line. The officers told another attendee that if attendees created a number system, the officers would honor it, and that this was how attendees would be admitted. The attendees then created a number system, and under it I was number 15. When we were told we could enter, however, everyone ran to the courthouse and the number system was not honored. Court staff admitted the first 27 people. I was the person immediately after the 27th. I was ultimately able to get in after lunch recess. From my understanding, there were 9 media passes and 27 passes for members of the public. Credentialed media, press, and news personnel had designated passes and did not have to stand in line. On multiple occasions, individuals who operated social media platforms told the deputies they were media and were allowed to move to the front of the line, ahead of members of the public. Attendees objected to the deputies that persons claiming to be media should not be standing in the public line, and that if they were in the public line, they should not be permitted to cut ahead. Each time the deputies responded that they had been instructed only to keep things calm and did not know how to control the line. During the times I was present at and around the courthouse, I did not observe any disturbance, security incident, or disruptive conduct by members of the public inside the courthouse that would explain or justify excluding the public from the courtroom. Over the course of the week, I was able to observe the jury selection proceeding twice, and I was able to enter the trial itself only on June 6th and the after the lunch recess for approximately 3 to 4 hours. Exhibit 15 is Miss Tamitra Carter. Okay, so this is a second separate statement from Tamitra Carter, not the one authenticated her record conversation with Sergeant Davis, which is its own exhibit. So in this one, she says she arrived before dawn and was actually number 7 on an earlier arrival list. She was still removed from the June 5th line and lost the morning proceedings because, again, only about 27 public seats were available. So let's read this one. I went to the Collin County Courthouse on June 4th, 5th, and 6th in effort to observe the trial proceedings. On June 4th, 2026, I arrived at approximately 6 a.m. There was already a line of members of the public waiting to enter the courthouse. Because of the limited number of public seats available, I was unable to obtain a seat in the courtroom that day. I understood that the court's order set a specific time for the admission of the general public. On June 5th, I arrived approximately at 4:30 a.m. and was among the first members of the public to arrive. When I arrived, I was informed that I could not remain at the courthouse because it would not be open until approximately 6 a.m. Members of the public were directed to wait at the nearby church until we were allowed to return. Before leaving the courthouse area, a member of the media recorded my initials and advised me that I was number 7 on the personal list he was maintaining of earlier arrivals. At approximately 5:30 a.m., members of the public returned to the courthouse. I was the first vehicle waiting to enter the parking lot, and additional vehicles lined up behind me. Before 6 a.m., the sheriff deputies temporarily moved away from the entrance. After hearing the vehicles behind me honk, I believed we were being allowed to enter and slowly pulled forward. When I saw deputies returning, I immediately stopped because I did not want to enter before I was authorized to do so. After I stopped, two vehicles behind me were involved in a traffic collision near the entrance to the courthouse parking lot. Law enforcement responded to the collision, and afterward, we were instructed to proceed into the parking lot. After parking, I attempted to approach the courthouse, but was instructed to return to a stop sign and lined up there. By the time I reached that location, approximately 20 or more people were already standing ahead of me, even though I had arrived among the first members of the public that morning. I ultimately found myself approximately 35th in line. I explained to one of the sheriff deputies that I had arrived early and did not understand how I lost my place in line. I asked whether the line could be reorganized or organized according to the order in which people had arrived, but my concerns were not addressed. I then spoke with the same media representative who had recorded my initials earlier that morning. He confirmed that I was number 7 on the list he had created. He attempted to explain this to the lead sheriff's deputy, whom I believe was named Brosco or Bosco. Brasco. The deputy did not recognize the list and directed that I be removed from the line after believing that I had skipped ahead. Because only approximately 27 seats were available to members of the public, being removed from the line prevented me from observing the morning proceedings on June 5th. On June 6, 2026, I arrived at approximately 3 a.m. because there was no official number system maintained by the court. Members of the public created and maintained our own numbering system while waiting in line in effort to preserve the order in which people had arrived. To the best of my knowledge, I still poses a photograph documenting the public numbering system that was used that morning. Members of the public were instructed to walk, not run, when approaching the courthouse. On June 6, 2026, I was admitted into the courtroom and was able to observe the proceedings. Based on my personal observations, there were no official system in place to preserve the order in which members of the public arrived at the courthouse on June 5th. As a result, despite arriving among the first members of the public and being identified as number 7 by the media representatives list, I lost my place in line and was unable to observe the morning proceedings. On June 6, members of the public created and maintained our own numbering system while waiting in line because no official numbering system had been established. Good man, this is crazy. So, Exhibit 16, this is the affidavit of Bridget Smith. Now, she attended on June 1st, 4th, 5th, and 6th. Her account confirms the 27 seat public cap, and she describes admission being split into two separate lines, one for people on the media list and the other one for everyone else. She also confirms the outside viewing location was eliminated once the testimony begun. All right, so I went to the Collin County Courthouse to observe the proceedings on June 1st, 4th, 5th, and 6th. On June 1st, I attended for the jury questionnaire session. I understood that the questionnaires would be completed that day and that jury selection would begin later that week. When I arrived, I asked the court coordinator where members of the public would be permitted to observe and whether any accommodation would be available given the significant public interest in the case. Officers led us to a room to sit, and it was my understanding and everyone else's we would be able to view the jury selection from there. We sat in the room for about an hour and began to ask questions, and someone came in and told us that jury selection was being held upstairs while we were all downstairs. We got up to see for ourselves and found a room full of people down the hallway. Out of what happened to be roughly 600 people, we saw only a handful of Black people. One of the officers from the room where we had been seated came and told us we could not be down there and that we needed to go back because they did not want us to taint the jury pool. I responded that if that was the concern, I did not understand why White Lives Matter have been allowed to pass out propaganda about the case to people going in a paper using the word Austin's murderer, which I was concerned would already taint the pool. We were sent back to the room where we were permitted even to view the proceedings on a television. Oh, hold up. We were sent back to the room where we were not permitted even to view the proceedings on television, and we were told we would not be seeing anything. In effect, we would be sitting in a room for the entire day for no reason, and no one was going to notify the people sitting there. We let the others know, and most people left, deciding to return on Wednesday or Thursday. I understood that the court's order set a specific time for the admission of the general public. We were told we had a time to get into the room and that we could not bring phones in, and people were even moved around in seating. Only for us to learn on our own that they were going to allow us to sit there all day and view nothing. The courthouse was closed on June 2nd. Jury selection began on June 3rd. On June 3rd, I decided not to attend jury selection, but to attend the first day of opening argument, which was Thursday. On June 4th, the first day of testimony, the court eliminated the additional viewing location. From that point forward, public access was limited to approximately 27 seats inside the courtroom. No overflow room, alternative viewing area, audio feed, video feed, and other accommodations was provided. When we arrived, there was a very long line of people in two lines, one for people on the media list and the other for everyone else. When they cut it off at 27 people, we asked whether there was an overflow room, and we were told no. Public seating inside the courtroom was limited to approximately 27 seats. Although the court's orders stated at the time of public admission, in practice, admission was determined by how early a person arrived and that person's place in an informal line, not by the time stated in the order. Members of the public began arriving as early as 4 a.m. to 5 a.m. to compete for a few available seats, and those who arrived after the line had formed often had little or no realistic opportunity to be admitted. On June 4th, I was unable to gain entry to the courtroom and was excluded from that date's proceedings. I stayed in the parking lot with others who had been turned away. Some people left. Some had driven in there from other states and deciding they would not have an opportunity to observe, made plans to travel back home. On June 5th, I again attempted to attend and was again unable to gain entry because of the limited seating and the admissions process. We learned that when people took breaks, they were told someone else could take their spot. So we went up to try to obtain a spot, but only about 6 or 7 seats were available for passes. As a result, some of those who had been waiting were able to go in, while some people who had left on their breaks were not able to regain access. On June 6th, I did not make it to the courthouse, but other people who had come with us decided to go and keep us updated. During the times I was present in and around the courthouse, I did not observe any disturbance, security incident, or disruptive conduct by members of the public that would explain or justify excluding the public from the courtroom. Yet I watched personnel remove people to whom they given passes over small, petty matters. One of the male reporters from South Carolina, hey, I was born there, who had been present from the beginning, was made to leave, as was another woman who had been inside. In my observation, neither one of them did anything to warrant removal, and I believe the reporter's rights were violated because they attempted to tell him that he could and could not say. What? And when he tried to assert his rights in a public courthouse, they told him to leave. On June 4th or 5th and the morning of June 6th, I and other members of the public were unable to observe the proceedings. The seats available to public were very few. The additional viewing location used during jury selection was discontinued once testimony began, and my ability to observe the proceedings was significantly curtailed as a result of the limited seating, the eliminations of the overflow room, and the manner in which access was administered. Boy, oh boy, oh boy. So the next one, this is Exhibit 17, Declaration of Miss Tony Toussaint. I hope I am saying her name correctly. Now, she is Carmelo Anthony's grandmother. This one hits a little bit differently, okay? Her statement is that family access was capped at 8 total seats, which meant that the defendant's grandmother and aunts were excluded from his trial altogether. She also states in this affidavit that family members who were admitted had to register a day in advance and was warned that a visible facial expression, so if they made any type of expression on their face, that can result as a removal from the court proceeding. Mind you, there were 15 seats for the prosecution and for the defense. Why was the defense only limited to 8? Her affidavit reads: Before the trial began, my daughter told me that access to the courtroom would be limited for family members. I subsequently learned that the family was limited to a total of 8 seats in the courtroom. I understood that the remaining seats were reserved for journalists who had been individually selected to attend and for members of the general public. In order to attend, family members were required to arrive at the courthouse by 8 a.m. and to obtain badges. In addition, a family member's name had to be placed on a list the day before in order to be admitted the following day. Before we left the courthouse each day, court staff would ask whether we intended to return the next day so that our names could be added to the following day's list. Because I was able to secure one of the 8 family seats, I was able to be present inside the courtroom each day of the trial. My husband, Carmelo's grandfather, was not able to attend of the 8 seats limited on um because of the 8 seat limit on family access. Carmelo's aunts, among others, were likewise not able to attend for the same reason. The judge instructed attendees that we could not speak while inside the courtroom, and we were told that if we did so, we could be held in contempt. We were also told that if we made a facial expression, we would be removed from the courtroom. Family access to the courtroom was limited to 8 seats total, which I understood to have been allocated among Carmelo's many family members, alongside seats reserved for selected journalists and the general public. Although I was able to attend each day trial of the trial, the 8 seat limit meant that other close family members, including Carmelo's grandfather and aunts, were not able to attend at all. Attendance also required advanced registration each day in compliance with strict conduct rules inside the courtroom, including um, them prohibiting them to speak, and if they, made a visible facial expression that can result in a removal. All right. So, Exhibit 18, this is Miss Thelma Anderson. She was excluded on June 4th and 5th, but on the 6th, she was eventually seated, but only in the mid afternoon after a substantial portion of that day's proceeding had already happened. So, let's see what she stated. On June 1st, I attended the courthouse for jury questionnaire proceedings. I understood that questionnaires would be completed that day and that voir dire would begin later that week. I approached the court coordinator to ask where members of the public would be permitted to observe and whether any accommodations would be available given the significant public interest in the case. The courthouse was closed June 2nd. Jury selection officially began on June 3rd. On June 3rd, the court provided an additional viewing location outside the let me see, where was I at? Outside. Why is it like like what? Okay, I'm gonna just start over. On June 3rd, the courthouse provided an additional viewing location outside the courtroom where members of the public could observe the proceedings. Although court personnel referred to the room by another name, it functioned like it was commonly known as the jury service or holdover room. This arrangement allowed members of the public who cannot fit inside the courtroom to observe the proceedings and reasonably accommodated the substantial public interest in the case. On June 4th, the first day of testimony, the court eliminated that additional viewing space and limited public access to approximately 27 seats inside the courtroom. No overflow room, alternative viewing area, or additional accommodations were provided. Public access was thereafter limited exclusively to small number of seats inside the courtroom. Although the courts ordered specified time, oh, I'm so sorry, y'all, for public admission, the practical reality was very different. Individuals began arriving at the courthouse during the early morning hours, often between 4 to 5 a.m., to try to secure one of the limited seats. The process became comparable to a race for access, with members of the public competing for a very small number of seats. Those who arrived after the unofficial line had formed often had little or no realistic opportunity to gain admission, regardless of the time stated in the court's order. In practice, access was determined not by the scheduled admission time, but how early um, a person arrived and whether the person was able to secure a favorable place in line. This system effectively excluded many members of the public from observing a trial that had generated substantial public interest. Because of these restrictions, I was unable to gain entry into the courtroom on June 4th. If there had been an overflow room, I would have went to the overflow room. On June 5th, I again attempted to attend the proceedings but was unable to gain entry because of the limited seating and admissions procedures. Recognizing the severe limitations being imposed, I submitted an application seeking media credentials and also requested that the court provide an alternative viewing location for members of the public. My request was intended to address the obvious capacity problem and to restore a level of access similar to what had been provided during jury selection on June 3rd. My request was denied. The process for seeking relief was itself problematic. Collin County's electronic filing system did not provide a mechanism for filing applications related to courtroom access in a criminal proceeding. Because the matter was a criminal case rather than a civil action, there was no designated filing category available through the standard e-file portal, and I could not formally file the application through the court's electronic filing system. Baby, I would have filed it under I think what they say, no fee documents or or a request. I think I looked on there and those two options were there, baby. And hey, every time it got kicked back or rejected, I would have kept filing to bug them. Instead, I was instructed that such requests had to be submitted by email directly to the court coordinator, who would then forward the request to the public information officer for review and response. This procedure left no transparent or clear avenue for members of the public to formally seek judicial review or to access restrictions. On June 5th, I received an email from Steve Stoller, who identified himself as Public Information Officer appointed by the 296 District Court for this trial, responding to my inquiry about media coverage and courtroom access. In that email, Mr. Stoller explained that the courtroom held only about 70 seats, that the prosecution and defense families each received 15 seats, that the judge allocated only 9 seats for the media, including one for a courtroom sketch artist, and that after court staff, only about 2 dozen seats remain for the general public. He further stated there is no overflow room. A true and correct copy of that email, which I have received and retained in this ordinary course, is attached as Exhibit A. Because remember, y'all, this stuff is supposed to be going on record. Throughout that email, Mr. Stoller described the courtroom access decisions in the collective first person. He wrote that he wished to explain the process we followed for media coverage, that we chose 8 media outlets for credentials, that we invited media members who were not approved for credentials to gain access with the general public, that we encouraged them to get in early, and that as much as we dislike turning people down, we had no choice. So he's speaking on behalf of the court. Hmm. The email's repeated use of we reflected my understanding that the selection of who would be admitted to observe the trial and the denial of access to others were administered by the public information officer rather than determined by the court in open record. Oh, the court in open court and on the record. Mm-mm. The explanation I received, those accommodations had been limited to local media organizations covering the case, did not, based on my observations of who was receiving access, appears to fully account for all individuals who have received accommodations or special access. Regardless, my request for the alternative viewing location was denied. The original guidance provided in individuals seeking access indicated that members of the public would not be permitted to bring notepads or pens into the courtroom. Although the court later modified this restriction and ultimately permitted notepads and pens, the original prohibition reflected the broader pattern of limiting public observation. On Saturday, June 6th, I returned to the courthouse and arrived early to try to secure one of the available seats. By that point, courthouse personnel and sheriff deputies had implemented a line system for admission. I initially obtained a position near the front of the line and reasonably believed that I would be admitted. The line process, however, lacked transparency and consistency. During the waiting period, individuals were permitted to move ahead of others who were already been waiting for several hours. As a result, despite having arrived early and secured a favorable position, my place in line significantly changed. I ultimately found myself approximately 35th in line, even though only 27 seats were available to the public. I was again excluded from the morning proceedings. After I was excluded from the morning proceedings on June 6, I remained at the courthouse for several hours. Had an overflow room been provided, I would have gone to it and observed the proceedings from there. Instead, I waited in the hallway for a considerable time with no access to the courtroom. In each instance in which I was excluded, I could observe the additional members of the public were excluded along with me. I was ultimately admitted into the courtroom in the afternoon of June 6th at approximately 2 to 3 p.m., but only after substantial portions of the day proceedings had already occurred, so that I was able to observe only a portion of the defense case. During the times I present in and around the house, I did not observe any disturbance, security incident, or disruptive conduct by members of the public that would explain or justify excluding the public from proceedings. While the courtroom may have been technically open to the public, meaningful public access was severely restricted in practice. Access depended upon arriving before dawn, enduring hours of waiting, navigating an informal and often changing line process, and competing for a very limited number of seats. The court's decision to discontinue the overflow viewing room that had been used during jury selection further exacerbated those problems, and requests for reasonable accommodations and alternative viewing arrangements were denied, despite the obvious demand and the court's own prior use of an auxiliary viewing room during voir dire. As a result, members of the public, including me, were repeatedly denied the ability to observe significant portions of the criminal trial of substantial public interest. The cumulative effect of these restrictions was to substantially impair the public's ability to monitor, observe, and evaluate the proceedings. Man, oh man. And here's the email. Here's the email. My name is Steve Stoller, the 296th District Court appointed yours truly as Public Information Officer for the Anthony trial. I wanted to take some time to explain the process we followed for media coverage. I'm not going to go through all this because you guys can see it. Definitely pause the video and read it. But he clearly says there are 70 seats in the courtroom. The prosecution gets 15 seats. The defense gets 15 seats for their family members. The judge allocated 9 seats for the media and one, including one for the courtroom sketch artists. Add court staff, and that leaves about 2 dozen or so seats for the general public. He has it on paper. Thank you, Steve. Thank you very much. Thank you very much, Steve. Okay. And there is actually, hold on, let me see. There was 18. Hold on. I know that there is another. Give me a second. There is another one specifically for, let me see. That's 19. Okay. This is the affidavit of Nakia Washington. Now, Washington's is different from the others. She describes as attending nearly the entire trial and proves the day to day account from the inside. And she corroborates the same features every other, declarant describes in their affidavit. And she confirms that she was excluded during the June 4th and 5th morning proceedings. And here's the line that ties all 8 together straight from the motion. So throughout, no declarant observed any disturbance, security incident, or disruptive conduct by any member of the public that would explain the restrictions. So keep that in mind, because and that's why I make sure I read that part so y'all know they did not observe any disturbance, no security issues, no one being disruptive, none of that. So this is the last one, the last affidavit. She traveled from Ohio to Dallas. All right, so I went to the Collin Courthouse. Let me make sure y'all can see this. I went to the Collin County Courthouse to observe the proceeding on June 1st, 3rd, 4th, 5th, 6th, 7th, 6th, 8th, and 9th. On June 1st, I attended the jury questionnaire session. Upon arriving, I was in the wrong area of the courthouse. A sheriff's deputy stopped me and directed me to the memorial room where members of the public would be permitted to observe. Deputies presented indicated that they were uncertain whether we would be able to view anything, but advised us to wait. After approximately 2 hours at around noon, screens in the memorial room came on and we were able to observe the judge speaking to the prospective jurors via live video and audio feed. The process that day was straightforward and without difficulty. The court's order set a specific time for the admission of the general public. In practice, however, access on later dates was governed not by the time, but by a person's place in an informal line that began forming well before that hour. The courthouse was closed on June 2nd. Jury selection began on June 3rd. On June 3rd, the court again made available an additional viewing locations outside the courtroom where members of the public could observe the proceedings. Court personnel referred to it as the memorial room, but it functioned as an auxiliary viewing courtroom. It has a separate courtroom that held approximately 60 members of the public and provided a live video feed and audio feed to the central jury room, allowing those present to observe the jury selection proceedings. The line on June 3rd was short. Entry was without difficulty, and I was admitted without issue. On the 4th, the first day of testimony, I and others who had arrived and waited in line were informed only after arriving that the overflow viewing room would not be made available for the remainder of the trial. From that point forward, public access was limited to approximately 27 seats inside the courtroom, no overflow room, alternative viewing area, audio feed, video feed, or other accommodations was provided to those who could not obtain one of those seats. Public seating inside the courtroom was limited to approximately 27 seats. Although the court's order stated the time for public admission, in practice, admission was determined by how early a person arrived and that person's place in an informal line, not by the time stated in the order. Members of the public began arriving as early as 4 a.m. to 4:30 a.m. to compete for a few available seats, and those who arrived after the line had formed often had little or no realistic opportunity to be admitted. The line process was inconsistent from day to day, at times chaotic, and on multiple occasions generated visible tension and disputes among those waiting. On June 4th, I was unable to gain entry into the courtroom and was excluded from the morning proceedings. After the line dispersed and most members of the public departed, I chose to remain at the courthouse on my own. At approximately 2 p.m., Sheriff Hunt approached me, as I was the only two of three individuals still waiting, and informed me that seats had become available. He escorted me inside and I admitted to the afternoon proceedings. By that time, a substantial portion of the day proceedings had already taken place. On June 5th, I arrived approximately at 5:50 a.m. Members of the public were already present and a line had begun to form. A traffic accident near the courthouse entrance caused additional disruption as people arrived. Deputies directed those of us who had exited our vehicles to form a line on the grass in front of the courthouse steps and then substantially to form a line at the courthouse door. The process was chaotic and generated tension. Several verbal altercations occurred among members of the public. One individual was removed from the line by a deputy and informed he could not be permitted to enter the courthouse the day after the dispute arose over individuals associated with the Metcalf family being permitted to move ahead in line without being directed to the back. At 7 a.m., the first 27 individuals were counted out, escorted inside, and issued badges. The remaining members of the public were permitted to wait in the courthouse corridor, where a bench across the courtroom held approximately 8 to 9 individuals who were next in line as seats became available. I admitted to the courtroom that after the lunch recess at approximately 1 p.m. Substantial portions of the morning proceedings had already occurred by the time that I entered. On June 6, I arrived in the area surrounding the courthouse at approximately 4:30 a.m. Members of the public were not permitted onto the courthouse grounds until 6 a.m. At that time, a line was formed on the grass in front of the courthouse. I was among the first 27 individuals counted out. Let's see, those 27 of us were escorted to form a line near the courtroom door, while the remaining individuals were directed to the opposite side of the building. Deputies stated the separation was intended to reduce the disputes and line skipping that had occurred on prior days. I was admitted to the courtroom that morning and was present for the morning proceedings on June 6th. On June 8th, I arrived at approximately 4:15 a.m. A line had already begun forming on the sidewalk outside the courthouse entrance. Though we were not permitted onto the courthouse grounds until 6 a.m. Several individuals were independent media credentials attempted to use those credentials to advance in line. Deputy Holcomb did not permit this, enforced the order of the line as formed, and instructed individuals not to run. Those of us identified as the first 27 were given business cards to identify our places, which we surrendered upon entering the courthouse. I was admitted that morning. On June 9th, I arrived at approximately 4:30 a.m. Ooh, kudos to y'all, because I was still asleep, and found the line already extending down the sidewalk. I was the 31st person to arrive. A friend who held a position ahead of me in line offered to switch places with me, which placed me at number 27. That day, the court counted out the first 26 individuals. However, I was admitted to the courtroom that morning and was present for the return of the verdict. During the times I was present in and around the courthouse, I did not observe any disturbance, security incident, or disruptive conduct by members of the public inside the courthouse. That would explain excluding the public from the courtroom. The verbal altercations I witnessed occurred outside the building in the prior line prior to admission. Once admitted, those present in the gallery and waiting areas conducted themselves appropriately. On June 4th and 5th, I was excluded from the morning proceedings on both days. On each of those days, I was ultimately admitted in the early afternoon after a substantial portion of the day's proceedings had already taken place. The seats available to the public were very few. The additional viewing location used during jury selection was discontinued once testimony begun without prior notice, and my ability to observe the full proceedings on those days was significantly curtailed as a result of the limited seating, the elimination of the overflow room, and the manner in which access was administered. On those days, or on the days rather, and the portion of days I was admitted, I observed proceedings that were conducted in an orderly fashion, and I witnessed no conduct that would have justified restricting public access to the courtroom. Now let's connect. We're going to connect the actual legal test. And if you have been tuning in for the past few days, you know what that legal test is. That is the Waller test. This is where the affidavits stopped being the antidotes and start being evidence. So this is evidence. That is why they were included in this motion for a new trial. But let's go through the Waller test, shall we? Factor one, overriding interest. So the motions makes a sharp point here. No party in this case ever formally sought closure, so no overriding interest was ever advanced by anyone for the court to weigh. And under Presley versus Georgia, that doesn't let the court off the hook. A trial court has to satisfy Waller even when it closes the courtroom on its own initiative without anyone asking. Factor two, narrow tailoring. This is where the affidavits do the most damage. None of the specifics appear anywhere in the written order. A roughly 27 seat cap for the general public, an 8 seat cap for the defendant's own family, enough to exclude his grandfather and aunts, a 2-track line system separating media list people from everyone else, a pre-drawn line forming between 4 and 8 I'm sorry, 4 to 5 a.m. that determined who actually got in, regardless of the order stating 8:50 a.m. entry window. None of that is narrow tailoring. That's an undisclosed, informally administered system that turned out to be far more restrictive than what the order itself describes. Factor three, considering reasonable alternatives. This might be the single strongest factor in the entire filing. The court had an overflow viewing room. It used it during jury selection on June 1st and June 3rd. Multiple declarants, these individuals in the affidavits, confirmed that it worked. And then on June 4th, right as testimony began, it was eliminated. No audio feed, no video feed, nothing in place. Presley requires courts to consider alternatives like exactly what was stated in Presley versus State. An overflow room with a closed circuit feed. In this case, in Karmelo Anthony's case, the court didn't just fail to consider one, it had one running successfully, and then they took it away. And factor four, specific findings. The order's actual language was that the case has generated substantial public and media attention. Y'all saw that this morning. That's exactly what that order says. And that unrestricted access may compromise security, jury privacy, and fairness, right? The motion points out that word may, and I'm doing quotations, is the problem. That's speculative possibility, not a demonstrated risk. And this is where Steedman versus State gets cited directly. The Court of Criminal Appeals already rejecting findings just like these, generic, categorical concerns with no specific threat or incident attached. These findings track the same pattern. Now, to be clear about what this is and isn't, there are the defense's own sworn exhibits filed to support their motion. The state hasn't had its opportunity to respond, cross examine the declarants, or even offer its own evidence yet. But in an evidentiary hearing is part of what's being requested in addition to this. So in the motion for new trial, they're wanting an evidentiary hearing. These facts are compelling as written, but they're not yet tested facts in the way that findings after a hearing would be. So, y'all, I am going to be tracking whether the court actually grants an evidentiary hearing on this. That's really the next thing to watch for here, okay? So continue to watch me for your updates on the Karmelo Anthony motion for a new trial, okay? In the comments below, y'all let me know which exhibit actually stood out for you, okay? For me, it's the overflow room. That's the biggest thing. Like you had one and then you took it away. And these what I stated yesterday, though, that is the biggest thing. This is a basic rule that all judges should know. It's not something like you came up with an order, then you amended that order, then you set restrictions, but then you didn't put specifics as to why these things was restricted. Why did you take the overflow room? And you can't just say because you wanted to protect the witness and jury and all this other stuff. That is general. That's generic. Because once again, you're basing it on a maybe. Nothing that demonstrated from either day justified the reason for you to close the courtroom or not even have an alternative where the members of public could be. But again, let me know which affidavit stood out to you the most. I'm Cassandra, aka your favorite paralegal, and this has been Legal Doc Talk. Bye.